All right, good morning. I hope it's morning when you see this. Um, I thought I might take a different approach to today's class. And so I am hopeful that this will be a useful way to actually have these notes. So here we go. On Monday, we started conversations about civil liberties. We went through the various definitions of the concepts. And so what I wanted to do today, I'm not going to go over the concepts again. Instead, I'm going to move so we went over the new terms. Here they are, and these slides will be up on Blackboard for your reference. So you will find that everything else that if you have a good grasp of these terms, then in practice, you really will have an excellent grasp of the rest of the materials. So again, here are the major terms that you're likely to find in this chapter. This is the second page of the new terms. Again, some of what we'll be doing is more explanation. All right, so we talked about, so if you think about the Constitution, the reason that the Constitution was created is to have a document, a contract, if you will, between the different individuals who made up the new American nation. If you go back to all the way to the Puritans and they're coming to the Americas, they were, of course, fleeing religious persecution. But one of the other things that was especially important was that, and that is true even today, Britain doesn't have a written constitution. It's a lot, so their laws are primarily based on common law. And so sometimes when people have understandings of certain things, it can work. But how do you know someone is not making up stuff? So a constitution made sense. And in it, there were specific protections that were listed. We mentioned, the writ of habeas corpus, the right of court to order an individual produced before it to determine, one, the legality of detention and maybe even try them. We talked about Bill of Attainder, which is when a legislative body passes laws that condemn a group of people without trial. Now, this is very rare, and actually what you might see that resembles Bill of Attainder is more of something like executive orders, where the president can, Guantanamo Bay, there are majority of that, even though Congress did eventually pass legislation. So leaders can do certain things without being held responsible, or perhaps even, but in England, there was the practice of using bills of attainder, which if a legislature passes law to say you're guilty, that sounds like something people can get out of. We also mentioned the incorporation theory under the 14th Amendment that basically incorporated the Bill of Rights to the states, as opposed to previously when it was only applicable to the federal government. So this sort of made both the Bill of Rights and state constitutions more harmonious But again, remember when we talked about the supremacy clause, if laws in a state violate federal law, then the supremacy of the Constitution on federal laws is enforced. Now, we shall talk a lot about ex post facto law and probably give examples, but this concept is Latin for after the fact. So this is what we shall be looking at, especially in this slide. So law that applies to events occurring before its enactment and which disadvantages the offender either by altering the definition of criminal conduct or increasing punishment. So there are quite a number of examples, including, for example, if a state enacts a law that outlaws chewing gum, then everyone who has ever chewed gum would be guilty. I would take another example. So imagine a state government outlaws, or maybe any government outlaws bicycles, or maybe riding bicycles. Then anyone else who has ever ridden a bicycle would be guilty of that crime. But I think a more appropriate example is California's three strikes law, which was enacted in 1984, which imposed a life sentence for any crime as long as the offender had 2 prior convictions. Now, there's a variety of these kinds of laws. I think there's federal law, and you probably are aware that this led to a lot of imprisonment of particularly African Americans on things like drug charges. So if California went back and resentenced or actually applied the 3 strikes law to anyone who had previously committed more than 2 felonies and were in jail, then that would be an application of ex post facto. Here's another example. Imagine if a country did not have the death penalty and then passes the death penalty, and the US, had outlawed the death penalty and then reinstated it in 1976. So if someone was convicted of something like murder, and the new law would have meant that they went to death row, then everybody else who was in jail for murder would then be on death row. So it's really not a great look to apply ex post facto law. But the good thing is that actually the US Constitution forbids it in lots of states. Yeah. So here, the Bill of Attainder, I wanted to briefly mention it again. So it was in use a lot in England, especially in beginning in 1326. And so Hugh Le Despencer, the first Baron of Le Despencer, and his father were the first who it was applied to them. And actually, they were hanged, drawn, and quartered. I think we mentioned some of this previously. So, hanging has been in many countries and places. Saddam Hussein was hanged in 2006, and, part of that American invasion. Drawn, usually a person would be like tied by their legs and they would be drawn by a horse, like a carriage. And then when they were quartered, literally their body was split in 4 parts, and these body parts would be sent to different parts of the kingdom. Now, there were sometimes there was torture in being drawn and quartered. So, for example, Hugh Le Despencer, and the punishment was for initiating a rebellion against the king. But they were really even minor. So, for example, if you thought of the death of the son of the king, the heir, that was a crime that you could be punished for with being hanged, drawn, and quartered. So Hugh Le Despencer was actually, like, his entrails were taken out and burned while he was watching. So usually when they did these kinds of punishments, people are not hanged to death. They were actually revived so that then they could be quartered, and it was so again, this constitutes cruel and unusual punishment. And so if you think you see two things that the new American Republic strictly kind of forbade. So this is cruel and unusual punishment, but they also forbade the use of bills of attendance. So the last time it was used was on Lord Fitzgerald in 1798, because he was rebelling against the British in Ireland. And so this is a depiction of his arrest. He was actually shot in the shoulder and died. So the bill of attainder was passed anyway, but he wasn't affected. So he wasn't, yeah. So the writ of habeas corpus is it's enshrined in lots of laws. So, for example, the American Constitution, but it originates in 1215 in Magna Carta. You might remember this as King John and the barons of the forest, and sort of so a lot of people say this created the first parliament, the first checks on the king and what the king could do. Specifically, Magna Carta's 39th clause, there's quite a number of clauses, read that no man shall be arrested or imprisoned except by the lawful judgment of his peers and the law of the land. So the king could now maybe not just have people killed randomly. So again, you can see the writ of habeas corpus, by the time it makes it into the American Constitution in 1789, had been in practice for more than 760, 70 years. So this is the writ of habeas corpus originating in 1215. This is the text of actually the complete text in modern English. No man shall be seized, imprisoned, dispossessed, outlawed, exiled, or ruined in any way, nor in any way proceeded against, except by the lawful judgment of his peers and the law of the land. Now, there was another clause. The second one should actually be number 40, not 39. To no one we will sell, to no one we will deny or delay the right of justice. So again, if you think about the amendments to the Constitution, so the right to a fair, speedy trial, and so this is what we're also mentioning, that habeas corpus requires you to be brought before court. And so this is one of the tenets of the American justice system, which in some other countries really just doesn't exist. You can be held forever on, just trumped up charges. Yeah, so it's useful to see how the American Republic borrows from Britain, but also the past, but also to the rights of individuals. So again, when you think about the Fifth Amendment, this is actually the complete text. No person shall be held to answer for a capital or otherwise infamous crime unless on a presentment or indictment of a grand jury. So the right to be, well, this sounds terrible, but everyone has it. People have the right to be prosecuted or to be brought before court. Now, it's important to, so this also speaks to double jeopardy. So nor shall any person be subject to the same offense to be twice put in jeopardy of life or limb, can't be tried for the same crime, nor shall be compelled in any criminal case to be a witness against himself. So again, you can be forced to testify. And so when you hear people say, I take the fifth, or I plead the Fifth Amendment. So you have refused to give information that would otherwise incriminate you. So again, you see these connections between old English law and more recent laws. So in maybe thinking about the enshrinement of these rights, habeas corpus, going back all the way from Magna Carta, cannot be suspended except if there's, well, in the Constitution, they say rebellion or invasion, but generally in times of war. And so here's two examples, and we mentioned on Monday that Guantanamo Bay is technically U.S. territory, but also it's not U.S. territory. And so the question of the writ of habeas corpus there is more challenging. But if you think about the Japanese internment, this is a good example of the suspension of writ of habeas corpus. You have been held, but you're not. It's only on suspicion that you could be aiding the enemy, even though, it's not clear that they would necessarily have aided Japan. And so this, so the clause 8 of the US Constitution, Article 1, Section 9, really, so Section 8 and 9 are these two. 8, the privilege of writ of habeas corpus, and 9 specifies that no bill of attainder or ex post facto law shall be passed. So here you see both are covered. So the US Constitution, the founders are saying you cannot pass a law to adjudicate someone as being guilty of a crime without actually trying them. But also, you cannot make something a criminal offense if by the time the law, you cannot retroactively apply criminality to things that were not criminal at the time that they were committed. So again, if you think about, I'm not necessarily sure that something like polygamy was widespread in the US, but when polygamy is sort of outlawed, you can then go back and say everyone who has 2 wives is guilty of a crime. These are, I think, especially important. So in the so that's the Constitution. But again, we have to remember that federalism is a relationship between the federal government and the state government. And so what is to prevent states from passing bills of attainders or ex post facto law? Actually, the US Constitution forbids it. Article 1, Section 10. So, all these other things, including, for example, entering into treaties, coin money, emit bills of credit, those kinds of things, or pass any bill of attainder or ex post facto law. So the Constitution also binds states to the same standards as the federal government in terms of bills of attainders and ex post facto law. Important to remember those things. So the reason the incorporation theory came into effect was, the bill wasn't applied, and so this was part of the Madisonian question of the relationship between the state government and the federal government. And so most founders didn't think that the Bill of Rights needed to apply to the states. The states had constitutions. So, for example, I think it was Thomas Jefferson who maybe drafted the Constitution of Virginia. I may be wrong on that, but so most states had already had a Bill of Rights. But again, we have to keep in context. For example, what did the Bill of Rights look like in the South versus in the North? Given their different economic trajectories. But also state governments are easy to control. We have, did I mention the lengths of constitutions and the things that are included in the amendments and the process of making these amendments? if you think about a state like Vermont, which I think has 600,000 people, clearly that's an easier, it's easier to pass laws or amend the Vermont Constitution, well, maybe more than California, but also more than the US. But also, there was a great fear of tyranny. So even though we have the um, the Federalist Papers, yeah, escape me for a moment. So even though we have the Federalist Papers and we have the agreements on the structure of government, there was still this fear that the national government could be tyrannical, and therefore the Bill of Rights was created for the national government. But there was nothing to stop state governments from being tyrannical, except then, after the Civil War, the 14th Amendment. Yeah, so the First Amendment is really important in terms of civil liberties, but it also has implications for how we live today. So if you're thinking about schools being a significant occupation of quite a number of Americans. So think about college students, high school students. The question of how the Constitution applies to this will be debated now. There have been many challenges that are related to the Establishment Clause. So the whether it's in schools or in churches, or whether school vouchers can be used for religious schools, whether, for example, school prayers can go on, whether students can recite the Pledge of Allegiance in that specific phrase, one nation under God. Is that maybe, because again, if you don't believe in God, and you have to recite the Pledge of Allegiance, what does that imply? Are you then saying you believe in some God? But so in a lot of there have been many cases that deal with the Establishment Clause. So, for example, in Lemon versus Kurtzman, where the Lemon test was created, the Supreme Court decided that aid to church-related schools violated the First Amendment. Another case was that of Engel versus Vital. I hope I say that right. That the state cannot hold prayers in public school, even if attendance is not required. And part of this has to do with the status of students. Do they feel threatened? And later on, there'll be what was called the coercion test. What is the implication of religious displays on public property? Can you do that? This was actually very interesting, and this might show you the differences between then and now. It was either Mississippi or Tennessee that decided to display the 10 commandments, either at the governor's mansion or at the state house. So, again, can that fall under Lemon and Kurtzman, or is this state government showing a preference for a religion? So the 10 commandments, if you're a Muslim who lives in a state like that, what does that imply? So these questions keep arising, but there are things that the government cannot do, for example, interfaith curriculum. But again, remember, we are talking about police powers. So the states have police powers. So whether evolution is taught or not, sometimes it's up to the states. So this, the Lemon test, and I'm not sure if I mentioned it yet, or if it's or if we are going to maybe then talk about the lemon test at some point. I do hope we are. But the lemon test was very instrumental in thinking about the intents. So the lemon test has 3 prongs, and hopefully I can find them. Lemon test. I thought I had them somewhere. So yes, these are called the 3 prongs. So especially for laws. Now, according to the lemon test, these are 3-pronged tests that a law must satisfy in order to be valid. So, for example, laws must have secular legislative purpose. Their effects cannot advance or inhibit religion. And third, the law must not foster excessive government entanglement with religion. And you can sort of actually apply these 3-prong test to even decisions, for example, like school prayer, or say something like if a school during graduation, and this is really actually this is where the coercion test comes in. So the things that the school does, if you object to them and it's a day that you're getting your graduation, say, for example, Norfolk State graduation day, and there's an invocation or a prayer, does that necessarily violate the, does it advance religion? Now, these are tough questions, but in particular, the Lemon versus Kurtzman was really an issue that related to whether the Elementary and Secondary, Non-Public Elementary and Secondary Education Act was unconstitutional, and whether it violated the Establishment Clause, which actually it did. Now, so the coercion test comes in another. Now, I hope that it doesn't sound like we are doing a lot of law-related stuff, but if you think about how we mentioned that laws are the 3 branches of government and their responsibilities, sometimes legislatures make laws. So, for example, that Non-Public Education Act in Pennsylvania, and then the courts have to interpret whether that violates the Constitution or federal laws. Now, so speaking of the coercion test, the coercion test stemmed from Lee versus Weissman. So, and this is something that I think is pertinent to many schools, perhaps even Norfolk State. And so the question, schools inviting clergy to give a prayer, public schools inviting members of the clergy to do an invocation or a public prayer. And the question was whether that violated the First Amendment, the Establishment Clause, by selecting a specific religion. Now, part of the challenge in the Lee versus Weissman 1992 was that Weissman was Jewish, I think. And so the minister who was invited basically involved said a prayer that you would expect, a prayer acknowledging God. But so then the question was, so then the question was, did that violate the First Amendment? And the finding was yes. So this is really what this was about. Students who object to the religious exercise, their attendance and participation in a state-sponsored religious activity are, in a fair and real sense, obligatory, even though the school district does not require attendance as a condition for receipt of the diploma. But the diploma is being given at the place where attendance is being, where the prayer is happening. So how do you get your diploma if you don't want to participate in the, unless maybe you can come late. And so then, Justice Kennedy goes further to reiterate that, for the school district does not require attendance as a condition for the receipt. How does that feel to teenagers? Do they feel completely unobligated? And so this is essentially the coercion test that Justice Kennedy kind of was thinking about. Now, people should definitely, people have the right to practice religion, but it's the question of whether it is publicly supported, for example, in schools, and what that implies for others who are not of the same faith. There has been questions so the military has certain standards for dress. Some of the ones that we know very well include the hair length. And so then the question is, can people whose faith require them to wear certain things? So if you think of the Amish, if they were, can you require them to dress different because they're serving in the military? Now, there's an argument to be made that, yes, if you're going to sign up to the military, the requirements, but then the question is, do the requirements of the military violate the First Amendment? Now, there has been, so this gentleman, I think, was in the US Army in Texas, maybe. And so the Army, again, think about the regulations. And if he's a good soldier, should he's wearing a turban and a beard according to his Sikh faith, SIKH, should that preclude him from joining the military? Or if he joins the military, should then he take down the turban and shave the beard? So again, if you think about the Establishment Clause, the Establishment Clause requires the government not support or inhibit a religion. Now, so again, sometimes the question is, the Army is part of the government, and so maybe it should not. It's an interesting phenomenon, but Gurpreet Gill was able to join the military, and the Army has kind of begun to relax those figures, and perhaps they might relax them more considering the dire straits they are in. So I think it was the other day I heard that they fell short of their recruitment goal by 60,000 this year, well, the past year. And so when you think about some of the questions of why they're not taking people in, and if religion was part of it. So again, if you think about people who wear religious clothing, I'm thinking here of hijab, which is mostly worn by Muslim women, covering So, well, hijab covers the hair. The niqab, NIQAB, actually covers literally the whole body. You just see the slits of the eyes. Um, but again, if you are taking a passport picture, you can't take a passport picture with a niqab. And so then the question is, if you go to TSA, would they force you to remove the niqab, and is that a violation of your religious freedom? So these are challenges that sometimes can be quite that require courts to maybe think about what was intended um, by things like freedom of religion, but also knowing that maybe at that time um, there weren't such, so there wasn't things like facial recognition. Last December, I was um, on a flight to Kenya, and um, Ethiopian Airlines actually uses facial recognition, but you have to actually show your face. And so what does that imply for religious freedom? There have been a lot of discussion about tax exempt questions of churches. So should churches pay taxes? Right now, generally they are tax exempt under 501c3, but can we really say that the churches are not into politics? So if you consider, for example, Martin Luther King, I would think that church and politics were the same thing, even though the government cannot fund churches. But on the flip side, if you think about those churches the mega churches that have many followers and lots of money, the question perhaps is, should they be paying taxes or not? Now, the federal government cannot fund the construction of churches or mosques or other houses of worship or religious buildings. But again, these are the contradictions in our lives. So for example, the Senate has a chaplain, and I believe the chaplain is funded by taxpayer money. He has a salary. So does that maybe then violate the establishment clause? Because then maybe that's preference for one religion over another. Again, these are issues to keep thinking about, and one of these days, hopefully, there might be insight from you about these issues. We talked a lot about prior restraint and these good examples of how you cannot impose prior restraint. We also talked about the protection of symbolic speech. Interestingly, most Americans will not. So there are things that, for example, people will do to demonstrate their dissatisfaction, which is the symbolic speech, like burning the flag. Most Americans think that should be a criminal offense. Now, the paradox is that people wear it on T-shirts and on beach towels and bikinis and things. Isn't that maybe also a violation of the flag? But there are these specific rules that apply to flags. So, for example, what time you raise it, not allowing it to touch the ground, and which side it faces. You can't hang the flag upside. You can't raise the flag upside down. So there are these rules, but the Supreme Court has ruled that flag burning is protected First Amendment speech. However much we might disagree with that. Now, cross burning has not. So even though the Klan was doing that, but that is a whole different. The cross represents the Christian religion, and so that is, it could be interpreted as, when we talked about imminent threat, burning of crosses can cause imminent threat. I don't know how much you know about other religions, but so, for example, one Iranian dissident, well, that's what they call him now, Salman Rushdie, wrote a book, I think it was 1987, which he titled Satanic Verses. And it was implied that he was talking about the Quran. And so the Iranian cleric, so the head of really the spiritual head of Iran, issued a fatwa, or it's not a verdict, but a fatwa requires that the person who is the subject of the fatwa to be killed. And so he has been under fatwa since then. The way people react to religious disrespect can be classified as imminent harm. And so, if you think about shouting fire in a theater, this is the same class of you. If you do this, you might then get people to start burning things, and that clearly is not, it's not good for anyone. So there's protected speech, and there's other things that you can do and things that you cannot do. Now, freedom of expression has been, we mentioned protection of commercial speech, but, and I wonder how you might feel about, so if you watch advertisements, very interesting. This advertisement was shown in 1946. More doctors smoke Camels than any other cigarette, and it is likely true that they do. But is this something that should be advertised? Now, over time, we have seen laws that bar the advertisement of the sale and advertisement of cigarettes and alcohol. Interestingly, for example, Virginia ABC, Bureau of Alcohol and something else, advertises, but they'll always have a disclaimer: drink responsibly. And so, are they encouraging people to drink? When you see advertisements for something like gambling, now we know what gambling is, and so there are things that I think. So something like burning a cross would be clear and present danger. Something would be a clear and present danger that would maybe potentially initiate imminent lawless action. And so these are not protected classes of speech. But so again, when you think about commercial speech, you can see how cigarettes cannot be advertised. And recently, Juul, or really more broadly, vape products came under scrutiny because the idea was that, even wherever you could advertise them, which is not many places, they were supposed to be an alternative to cigarettes, but it was found that they were actually more addictive than perhaps cigarettes, and they contain more nicotine. And so, it's important to, to think about whether protected speech or commercial speech advances the welfare of the citizens. Now, the bad tendency principle is a test that, or the bad tendency rule, is the idea that certain speech might produce or incite or cause illegal activity. So if you think about, for example, January 6th, 2021, you literally see these three things. It's the clear and present danger. And so can you then inhibit speech if there's clear and present danger? The bad tendency. So speech that has the sole purpose to incite or cause illegal activity. One could argue that that was, clearly intended to cause people to, because if you say we are going to march to the Capitol, what does that, to march there and do what? So the implied tendency, but also imminent lawless action, we would think that that would be occurring in those kinds of situations. So when we think of freedom of speech, there are important questions over whether obscenity is protected speech. There was a case that came before the Supreme Court in 1964. And if you think about 1964, there wasn't a lot of maybe open-mindedness. That was before the Summer of Love. And so, a Supreme Court case came before the Supreme Court, and a case came before the Supreme Court. And Justice Porter Stewart is famously quoted as saying, "I know it when I see it." And the question really before them was, how do you define pornography? So then if pornography is a bad thing, maybe it's not protected speech. But what constitutes pornography? And so this is where Justice Stewart saying, I know it when I see it. And so this was the, what's this case? Yes, so Jacobellis versus Ohio. And so this became the sort of the threshold test. So this is actually the full quote from Justice Porter Stewart. "I shall not today attempt further to define the kinds of material I understand to be embraced within that shorthand description, hardcore pornography, and perhaps I could never succeed in intelligibly doing so. But I know it when I see it, and the motion picture involved in this case is not that." So there's the question of whether something, Jacobellis versus Ohio, distribution of materials, and whether what constitutes obscene material and whether that is protected or not. Now, these other cases, so for example, Roth versus United States, that held that obscenity is not protected by the First Amendment, but also strictly defined obscene. And so definitions are important. Saying I know it when I see it sounds like, okay, but one man's, what do they say? Yeah, I'm not certain that everyone knows it when they see it or that the standards are the same. But also, we now face the internet, pornography, and those kinds of things. As I don't know if it was to you, I was mentioning that in Alabama now, the state is requiring individuals to basically register to access certain pornography websites. And so the question is this maybe a hardship? Is this what's the government going to do with that information? But part of the intended outcome is that pornography should not be available to certain younger people. So, again, it's important to sort of think about the precedents. And now I should mention Miller versus California. So the Miller versus California case was about Miller sending these items. So these were the first four, 1, 2, 3, 4, were, I think they were magazine articles or booklets, or actually they were advertisements. The fifth was a film. And so the question was whether Miller violated California law by mailing this. Now, everybody thought that he violated California law, but over time, this was in the maybe 70s, over time, there has been a sort of redefining what is obscenity. And so before we actually talk about obscenity, so there is what is called the Miller test for obscenity. And so this was for the longest time the standard that even though Justice Stewart was thought that you know it when you see it, the Miller test was more concise. And these were the 4 tenets. The average person finds that it violates contemporary community standards. The work as a whole appeals to a prurient interest in sex. And this speaks to, it is intended to promote the perhaps ideas around or exposure to so if you think about pornography, that would be a good example, like actual porn. But then what is that? The work shows patently offensive sexual conduct, and the work lacks a serious redeeming literary, artistic, political, or scientific merit. So especially the fourth category, we see quite a bit of like if you think about some of those pornographic materials, literally most of it would fall short of number 4, serious, redeeming literary, artistic, political, or scientific merit. And so if it meets these 4 conditions of the Miller test, then it's obscene. But now there's still a lot of censorship around obscenity. And I'm sure if you've gone to, well, I don't know if you go to movies but when you do, you will see that screen that comes up first that says MPAA, and it has rating, Motion Pictures, something of America. And so the children are still protected. And, that I think is especially prudent, because now with internet, and you've heard all the horror stories, it is necessary and proper to protect children. But so this is the Miller case, and these are the justices. And so the provisions of the 1996 Communications Decent Act violate the First and Fifth Amendments. Actually, the case only addressed the First Amendment. So the Communications Decency Act regulations were essentially content-based blanket restriction of the speech or free speech, even though it may be something that is maybe improper. But also the Supreme Court argued that the Communications Decency Act did not define indecent. So what is indecent and whose standard are we talking about? Because if you, I hear about some of these things. If you're thinking of nudists, what would be indecent to them may not be, or what would not be indecent to them may be very highly indecent to people who are strict religious, who are adherents of their religions. So, in fact, one of the findings was that the Communications Decency Act could be saved if it dropped the indecent from its text. So again, it was the ruling found that the Communications Decency Act did not limit restrictions to particular times or individuals. So again, adults have choice. Now, children, on the other hand, protecting them. But should you then maybe limit adults? It did not also provide any authoritative or authority or unique nature of internet communication. So is pornography harmful when transmitted through the internet? So if you maybe think about hacking, you would say yes, because hacking can produce many, I think, untoward. If children are hacked and they're in computers, and I think I recall reading something about, especially during the COVID pandemic, streams being hijacked and inappropriate content being shown. So that this is, I think, a critical issue. But also that the transmission of offensive material is devoid of social value. And so the question is, why are they insinuating that there's social value in offensive material? Now we have talked about some elements of unprotected speech. So for example, slander, slander is a public uttering of a false statement that harms a good reputation for another person. So think about slander, think about libel, and those other concepts that we discussed previously. So these are not protected. So slander, libel, and so on, although the thresholds are very, very high. And so if you recall, recently there was a case where Donald Trump tried to sue the New York Times and say they, tarnished his reputation. Very interesting that he actually has one. But so when you think about the implications of something like that, slander is not protected. Now, the other major question is whether students have freedom of speech. And this is, students do have freedom of speech. They have rights. Now, the more challenging question is one of how that speech impacts other people. There was an individual, I think, in University of North Carolina, Wilmington, who expressed very interesting opinions and said, for example, that he believes women should not work, that they should be at home raising babies. And he actually, I think, expressed this to his students. And so the question for the university was, I think there were tweets, were they going to still keep him? Eventually, he resigned, but also there are students, especially in college, have recourses like refusing to take classes with certain professors. I think there's another professor in one of the Ivy Leagues who, female, I forget if her name was Waxman, who was also making statements that sounded, yeah, actually, I think I remember she said that Western Caucasian persons had more intelligence than maybe other people, and she stood by that statement. I think she was teaching at Penn State or UPenn. Um, and so the question is that protected speech? We then run into the questions of political correctness. Is political correctness protected speech? If So, for example, if I say ladies and gentlemen, and someone identifies as, say, a non-binary individual, is that a violation of their sense of self? Um, so, but also, campuses have been known for restricting the speech of people who might espouse different ideals. Not sure if you know who Nick Fuentes is. He is some people say he's a white nationalist and probably a neo-Nazi. And there have been instances in which he was going to speak at university campuses, and there were protests against that, and that was seen as political correctness. So there are these questions of what can be done, but we also, what is protected speech? Now, I want to maybe briefly mention Paul O'Brien. So Paul O'Brien destroyed his draft card in 1966, and then he was arrested and prosecuted. Eventually, there was what is called the O'Brien test for federal laws. That impact expressive conduct. And so the Supreme Court again ruled that they think it's clear government regulation is sufficiently justified if it's within the constitutional power of the government. So this is a Miller test for things. Can the government make, or can Congress make laws and enforce them, like tearing up a draft card? Now, O'Brien was an anti-war protester, so he didn't believe he should go to war, even though one thinks maybe he could have used the conscientious objector, like there was the opportunity and option to refuse the draft because you opposed war. But destroying his draft card was adjudicated to be a criminal offense based on these four conditions. So government regulation is sufficiently justified, furthers an important or substantial government interest, so in this case, a war. Government interest is unrelated to the suppression of free expression, and the incident is no greater than is essential to the furtherance of that interest. So government can pass laws, and so if you think of selective service, even though it hasn't been used in quite a while, the basic idea is that the federal government or Congress can make laws if they further the interest of government and governing. Again, mentioning the rights of students, one of the most important cases is Tinker versus Des Moines. And so this is basically the skip that. So this is the O'Brien test. Government regulations is sufficiently justified, furthers an important or substantial government interest. Yeah, so this is the O'Brien test. Now, students, as we mentioned, have free First Amendment rights. So this is the case of students in Des Moines protesting the Vietnam War, so they were going to wear black armbands. The principal said, you can't do that. And they did it. And then they were suspended, and so they sued. They lost and eventually appealed to the Supreme Court. And so this is what the Supreme Court adjudicated. Neither students nor teachers shed their constitutional rights to freedom of speech or expression at the schoolhouse gate. School officials should not prohibit on only the suspicion that the speech might disrupt the learning environment. So again, here we see the interplay of, you cannot ban speech because you think that it might cause disruption. Especially in this case, the Supreme Court asked whether the armbands were going to impact the teachers, or basically how they were going to impact teaching and learning. And they didn't think that teachers should be disrupted by students wearing a black armband. So this speaks to prior denial of freedom of speech. So you cannot prohibit on suspicion that speech will disrupt the learning. So it's almost like you have to let the disruption occur, and then if it occurs, then you can do something about it. But it's, I think, important to remember that the constitutional rights to freedom of speech or expression they don't end at the school gate. So there are, when you think about the right to petition, assemble and petition the government, some of these includes, for example, protests. And if you think about petitioning government, sometimes it's not a very organized affair. Think about the social justice protests of 2020, George Floyd, but also even most recently, Terry Nichols. That is petitioning government. Now, we talked about defamation and libel. Now, it's useful to think about libel. So the US is one of the most permissive countries on earth. If a country like, say, I don't know, Iran controlled YouTube, you probably wouldn't see pictures of cats and terrorists on there. But so other countries they are less forgiving. There are many instances of countries cutting off internet access, because if you say bad things, or if you write bad things about leaders and so on, post them online on the internet, that is considered libel. And but in the US, it's more difficult to prove. So on that account, the US has, I think, more freedoms. But this is a good chart to sort of think about the differences between libel and slander. So again, if you go through this chart, is it written or spoken? Is it untrue? Does it damage the person's reputation? Does it involve a public figure, malicious intent? Was it known to be true, or should it have been known? So, for example, if you take something like Dominion machines, the case that is before courts now, whether it was known or should it have been known. So, for example, it's easy to decide that is what Fox News did was amounted to libel. But especially, the Fox News newspapers. But again, if you quote someone, what does that imply? Is it So if it's spoken, like on many TV shows, is it untrue? Does it damage a person's reputation? Was there malicious intent involving a public figure known to, but also with the spoken part, for slander, someone else has to hear it. Now, I don't know if the listeners would count as someone else, but it's useful to think about, what constitutes slander, what constitutes libel, what constitutes defamation, and so on. Now, there's been many questions about the right to abortion and privacy. Roe v. Wade, 1973, that was recently overturned by Dobbs v. Jackson's Women's Health Organization. And so there are some, and I mentioned this, Griswold versus Connecticut, which asserts that the right of marital privacy against state restrictions in the use of reproductive health was protected under the was protected. Griswold versus Connecticut, right of marital privacy against state restrictions in reproductive health were protected. But again, as happens with these things, the question was, okay, so is that discrimination of couples who are not married? And so if you actually apply Griswold versus Connecticut to, say, Obergefell versus Hodges, or maybe it's a better application of Einstein versus Bird, which extended Griswold to single people, because then that, in theory, discriminated against single people. And so now they also had the right to access contraceptives and make reproductive health discussion or decisions. So if you think about the application of these two cases to marriage, when marriage was defined as between a man and a woman, then the question was, is that discrimination? Does the Equal Protections Clause not get violated if you only select the certain people who can be married? But also the question is, what is marriage? And that's an interesting question. So if you think about like common law marriage and so on, because if something is defined as a thing, can you extend the definition of the thing? Actually, maybe you can. So think about the US Constitution and maybe the Declaration of Independence. All men are created equal. If we are just talking about men, but since we extended this to women, so maybe concepts have more than one meaning, like marriage is between two people. But you begin to see the issues that the Supreme Court actually has to contend with. So the Equal Protections Clause was applied in Bird to bring single people on the same level with Griswold versus Connecticut. Now, I'm not sure that the Supreme Court has necessarily, there are those who say that Dobbs v. Jackson Women's Health Organization throughout Griswold versus Connecticut, but I don't know that it did that, except in instances of pregnancy. Although, the question of whether contraceptives should be allowed is actually beginning to come up, and it's sort of like, is this 18th century America? But hey, it's all now. So the right to petition government includes a right to protest. And we have seen this a lot, whether you're protesting abortion or killings of Black men by police officers, we do see those kinds of things. So, but there are people who protest in what can only be defined as imminent threat. So in 1996, a number of abortion clinics were bombed in Atlanta. 1996 was, I think, the Olympics were in the US. And so some people go radical, and so those bombings were, there are ways to protest. Sometimes these include going to court and arguing your point. So currently there's a court case that is in Dallas, Texas. The judge who is presiding, I'm not even going to try to mention his name, but the question is whether the authorization of mifepristone was violated the law, whether FDA violated the law in approving. So most people will call it the abortion pill. And so and the judgment, I think, was expected on 14th of February. I haven't heard about the judgment yet. But if the judge finds that the FDA should not have approved that particular abortion pill, then, what does that imply? Particularly given the reversals that Dobbs versus Jackson Women's Health Organization brought about. Now, of course, people can protest these things, and protest is a form of political expression. Voting is a form of political expression. And so what do these things mean? And how does something like the right of women to make reproductive health decisions become enshrined in ways that are incontestable? But most importantly, remember that the right to petition government is absolute and part of the First Amendment. The more maybe contentious question that has been arising is privacy and the right to die. Do people have the right to die? So, for example, there will be people who will leave or who will write a will and have, for example, what's called DNRs. Do not resuscitate. So when in certain conditions, whether that person intends to be resuscitated or provided medical care. I'm sure you have probably heard that the oldest living American president, Jimmy Carter, has chosen to forego treatment and is in home hospice care. So those are decisions that are related to privacy. Now, these questions of something like physician-assisted suicides, which the Northwest has elements of, and so the questions are: can states ban abortion and still allow physician-assisted suicide? So, as you can see, it's not many states that allow it, but this continues to be a major issue. Do people want to live a life of dignity, or do they want to, choose the place, time, and maybe a method of ending their suffering? But then what do states do about it? Do they allow it? Does that amount to maybe violation of the concept of pursuit of life, liberty, and happiness? So these are really major questions that are bound, I think, at some point to come to the forefront in terms of needing discussions. Europe is a little ahead of the US on this. Lots of states will allow physician-assisted suicide. So good to keep an eye on the debates on that. Now, one of the biggest challenges to security issues is, or the biggest contention is the intersection between security and civil liberties. When can the government violate your civil liberties? Can the government listen to your phone calls and monitor your texts and so on? So after 9/11, the USA Patriot Act allowed for interception of communications and so on. So if some person that is thought to be anti-US is calling or texting you, that allows the US government to listen to those phone calls, but otherwise it should not happen in the US, even though it was recently discovered that the US was collecting a lot of data on US citizens without warrants, which is supposed to not happen. And so if you think about some of the more recent cases where we've heard that the US was maybe caught doing surveillance on individuals, for example, on foreign embassies, and I guess they should probably be doing that, like cables, WikiLeaks, if you have heard of it, or for example, the Snowden, Edward Snowden, who leaked information about NASA's, or rather NSA surveillance tactics and so on. Now, of course, the US will say we are trying to keep safe and know which terrorists are talking to which ones and planning what. But with that impacts Americans, what does that mean? Does it violate the Fourth Amendment? Now, usually the government can go to what is called the FISA court, Foreign Intelligence something court, and you would never know that you are the subject of surveillance until so the question is whether, for example, the Patriot Act violates the Fourth Amendment, and this will continue to be discussions, especially in light of like China balloon and so on. So there are two cases that I think are very interesting to keep an eye on that are going on now. So there are debates about the responsibility of tech companies and whether they should allow things, for example, something like posting of Al-Qaeda and Al-Shabaab and ISIS videos to the internet. And part of the question is, they're not even American. Why would they be allowed to do that? So there has the cases, and you can see they're quite, this is like 5 days ago, two cases that argue that the US, that the tech giants should compensate the families of these individuals who are killed in terrorist attacks because the major social media companies allowed these terrorist groups to post and videos and recruit other people who then committed those crimes. Now, the tech companies are like, well, we can't control everything, But do they have a responsibility to maybe just look out for those things? So this is very interesting to see what will happen, and what, and if you think about the Congress now, if you think about the debacles with Twitter, there's these questions of, is big tech too big, and what should be done about that? So in the contemporary world, you think back to the Constitution and think about the things that it did not foresee, and ask yourself, how do we bring the Constitution up to date without amendments? It's almost 250 years since it was, put out there. So yeah, these questions regarding, there are limits to some of these rights, even in the US. So for example, in there was, during the Trump presidency, Title 42 law that said, if you cross the border, you would be deported immediately. So Americans have these due process rights. Most immigrants or visitors do not. There are questions of who you associate with, and if, for example, you're coming from certain parts of the world and you have a name that looks like other names, so a lot of times, most foreign persons coming to the US have fewer rights than Americans. And one of those, for example, is the ability to search your phone. This actually happened, I think it was in 2019. WhatsApp, some student was going to Harvard, came from Palestine, and the immigration searched his phone and saw some picture that was inappropriate. And the insinuation was that this particular student supported terrorism, and so he was deported. So now, as an American, they can't ask you to unlock your phone without a warrant. So, but for foreigners and immigrants, there's fewer rights. Now, these rights that are due of Americans, even though sometimes we see them violated. So, for example, these extrajudicial killings of especially minority populations, especially African Americans, is clearly violation of individuals' rights. And then it becomes difficult to argue that conduct of police officers is limited by laws and the Constitution, because if you think of Tyree Nichols or George Floyd, even though it was in trial, that was deprivation of life. And so, should there be more, maybe, I don't know, care taken to enforce the laws? Now, if you have followed the George Floyd question, one of the police officers was brought up on federal civil rights charges because he violated the civil rights of George Floyd. So again, we do see these things, but I don't know if it's helpful if you have passed away from your rights being violated. So while the laws are there, the execution is not always perfect. But we have mentioned, Miranda v. Arizona. And so, when we think about arrests or detention, police are required to read you your Miranda rights. And if they don't, then that is grounds for dismissal of, And, again, if you see some of these shows, you'll see a defendant ask for an attorney, or will say, I'll only speak with my attorney present. So Miranda was arrested, questioned for like 5-6 hours, and he wasn't told he had a right to not speak to the police officers. And yeah, so important to know the Miranda rights. Now, trial by jury is a very interesting concept because it encompasses two things. One, people can choose to be tried by a jury. Sometimes they choose to be tried by a judge. And so the Constitution affirms your right to be tried by a jury of your peers. Now, again, sometimes it's the application that is flawed rather than maybe maybe more than the intent. Because if you think about a jury of your peers, who are your peers? If you are an African-American man and there's a jury with 12 white people on it, are those your peers? So these are things to, I think, keep in mind.
Dating back at least to the time of Socrates, some early societies decided that certain disputes, such as whether a person committed a particular crime, should be heard by a group of citizens. Several centuries later, trial by jury was introduced to England, where it became a fundamental feature of the legal system, checking the government and involving citizens in decision-making. Juries decided whether defendants would be tried on crimes, determined whether the accused defendants were guilty, and resolved monetary disputes. While the American colonies eventually cast off England's rule, its legal tradition of the jury persisted. The United States Constitution instructed a grand jury to decide whether criminal cases proceeded, required a jury to try all crimes except impeachment, and provided for juries in civil cases as well. Yet, in the US today, grand juries often are not convened, and juries decide less than 4% of criminal cases and less than 1% of civil cases filed in court. That's at the same time as jury systems in other countries are growing. So what happened in the US? Part of the story lies in how the Supreme Court has interpreted the Constitution. It's permitted plea bargaining, which now occurs in almost every criminal case. The way it works is the prosecutor presents the accused with a decision of whether to plead guilty. If they accept the plea, the case won't go in front of a jury, but they'll receive a shorter prison sentence than they'd get if a jury did convict them. The risk of a much greater prison sentence after a trial can frighten even an innocent defendant into taking a plea. Between the 19th century and the 21st century, the proportion of guilty pleas has increased from around 20% to 90%, and the numbers continue to grow. The Supreme Court has permitted the use of another procedure that interferes with a jury, called summary judgment. Using summary judgment, judges can decide that civil trials are unnecessary if the people who sue have insufficient evidence. This is intended only for cases where no reasonable jury would disagree. That's a difficult thing to determine, yet usage of summary judgment has stretched to the point where some would argue it's being abused. For instance, judges grant fully or in part over 70% of employers' requests to dismiss employment discrimination cases. In other cases, both the person who sues and the person who defends forego their right to go to court, instead resolving their dispute through a professional arbitrator. These are generally lawyers, professors, or former judges. Arbitration can be a smart decision by both parties to avoid the requirements of a trial in court, but it's often agreed to unwittingly when people sign contracts like employment applications and consumer agreements. That can become a problem. For example, some arbitrators may be biased towards the companies that give them cases. These are just some of the ways in which juries have disappeared. But could the disappearance of juries be a good thing? Well, juries aren't perfect. They're costly, time-consuming, and may make errors. And they're not always necessary, like when people can simply agree to settle their disputes. But juries have their advantages. When properly selected, jurors are more representative of the general population. and don't have the same incentives as prosecutors, legislators, or judges seeking re-election or promotion. The founders of the United States trusted in the wisdom of impartial groups of citizens to check the power of all three branches of government. And the jury trial itself has given ordinary citizens a central role in upholding the social fabric. So, will the jury system in the US survive into the future?
So that is really a good question. Will it survive? Perhaps it will. Now, maybe one more thing to mention is the exclusionary rule. So you have heard, or maybe you haven't, there's a concept called a chain of custody. So if there's a crime scene, it's secured. And if there's an article that might be of interest to prosecution, it's also, they have to make sure that, it wasn't tampered with. There's less leeway for evidence tampering, and evidence tampering can cause court cases to be thrown out or even convictions to be thrown out. But also importantly, illegally obtained evidence cannot be used against an individual. So if the police break into your house and search or wiretap you and you don't know, that cannot be used against them. And so there's still some guardrails to individual rights, even though we also see quite a bit of leeway towards there's probably more of a tendency to believe the officials like police and so on, then perhaps. So if, for example, I say, well, they obtained this illegally or I was coerced, if I don't have bruises, or then was I tortured to give the evidence? So it's a concern when accused is in police custody. We did talk about the cruel and unusual punishment, but it's important to maybe focus on the death penalty. So if you look at this, you will see sort of there are right, hopefully this is still recording. That was unfortunate, but it happens. I think it's still recording. So this is probably the last slide, I think. There are states that have abolished the death penalty, and more we see that may be happening, especially north and northwest, northeast and west. Most of the other states have not abolished the death penalty. Now, there's all kinds of challenges to the death penalty, including not only the constitutionality, but also whether it imposes cruel and unusual punishment. And we have seen quite a number of botched execution attempts. And so, can we be sure that it's, but again, there's those who say there are some crimes for which the death penalty is warranted. Again, that's probably why you see so many states that still have it. So 21 states have abolished the death penalty. But the territories do not have the death penalty. Now, if you look at the numbers, executions since 1976, one might want to think that it has something to do with population, but again, look at Florida, Texas. Actually, Texas is sort of the death capital of the United States. It's not even a question of population because California has a higher population. And so is there perhaps more injustice in Texas, in Florida, in Georgia? Because these are some of the highest numbers in Ohio, in Missouri. And so the question of a jury of your peers that might sentence a defendant to death is a most important question, particularly if you consider the history of racism in the US, and the question of whether the jury is truly of your peer. Now, so you can see also the death row population, quite a number of people. So California is leading in that category, and then Florida is up there somewhere. But countries like Pennsylvania, states like Pennsylvania, North Carolina also have their numbers up there. And so, these questions of whether cruel and unusual punishment is included in something like the death penalty. And so this, I think, brings us to the conclusion of our conversations on civil liberties. And so hopefully by now you can do all of these tasks, like explaining how the First Amendment's Establishment Clause and Free Exercise Clause guarantees our freedom of religion, and so on. So please ensure that you take a good read of this, and we shall convene next time.